Hello, guys, and welcome to Study Time Anytime. Continuing the series of constitutional law, the important case laws that belong to the Canadian Constitution, will start from the 13th most important constitutional case law that has changed the entire scenario and has clarified the definitions and importance of the Canadian Constitution. So the heading is Equal Parental Benefits. Shlomo Spector took 3 weeks off work without pay to stay home with his newborn. He applied for paternity benefits under the Unemployment Insurance Act, which provided parental benefits for adoptive parents. His application was denied. He argued that he was the subject of discrimination because the act treated natural parents and adoptive parents differently. The Supreme Court agreed, concluding that the act created unequal benefits contrary to the equality rights guaranteed by the Section 15 of the Charter. The court used this case to explain what courts could do when one part of law unjustifiably limits charter protected rights and freedoms. When this happens, courts can strike down the part of the law that is inconsistent with the Charter, among other remedies. In some circumstances, the courts can also read words into the law to make it consistent with the Charter. So, where there has been differentiation or discrimination made between adoptive parents or the natural parents and the natural parents, so in that case court found it against the Section 15 of Charter, and it declared that such discrimination is not within the ambit and nature of the Charter. So the court can strike down the part of the law that is inconsistent with the spirit of the Charter. So this is the case law, case title, and the year is 1992. Next is publication bans during trial. 4 men who were members of a Catholic religious order were charged with sexual assault. Following their arrest, the Canadian Broadcasting Corporation and the National Film Board tried to air The Boys of St. Vincent. The film was a docudrama that was inspired by the events similar to those allegedly committed by the above-mentioned 4 accused. A lower court judge banned the docudrama from airing until after the trials, stating that it could violate the man's right to a fair trial. The Canadian Broadcasting Corporation and the National Film Board argued that this ban violated their freedom of expression. The Supreme Court stated that the parties seeking a publication ban must demonstrate that there is a real and substantial risk noted down. The Supreme Court stated that you need to demonstrate that there is a real and substantial risk of interference with the right to a fair trial. Though the ban was meant to prevent this risk, it was too broad in its application. The court held that the ban was unconstitutional and infringed freedom of expression because it was unjustifiable. Freedom of expression and the press are necessary features to a free and democratic society. So, no ban can be imposed illegally, unjustifiably against the freedom of expression and the press, which is the necessary part and spirit in the rights enshrined in the Charter. Any measures that ban media from publishing information of interest restricts these freedoms and must be justified as reasonable and proportionate to the reason for the ban. So this case relates to the year 1994, and the title is Dagnice versus Canadian Broadcasting Corporation. Next case law relates to equality for people with disabilities. Susan Eldridge, John Warren, and Linda Warren were born deaf. They preferred to communicate through sign language. While provincial law provided funding for medically required services, no funding was available for sign language interpreters. They argued that this infringed their equality rights. The Supreme Court agreed, concluding that their equality rights were infringed because they were denied the equal benefit of access to medical care based on their disability. Without sign language interpreters, people who are deaf would not be able to effectively communicate with their doctors, which increases the risk of misdiagnosis and ineffective treatment. The case shows that equality does not necessarily mean identical treatment for everybody. In certain cases, disadvantaged groups may need more services or programs. Government, employers, and service providers need to consider the need to eliminate barriers to allow for the full participation of persons with disabilities in the Canadian society. Eldridge versus British Columbia Attorney General 1997, 3 SCR 624. Stay tuned for more case laws. Thank you very much for discussion.